Yes, Mr. Cairns.
Lord, we were in the midst of Cave, and I had made the point that there had been debate as to the significance of the fact that recklessness would not be covered under the narrow construction, which was eventually accepted by their lordships. And I was making the point that it's against that background that one must then turn to consider the language they use in the judgment. And by way of example, if one looks at page 528 and looks at paragraph 24 of Cave, third line down, it is only where the defendant is aware of his own deliberate wrongdoing that it is appropriate to penalise him for failing to disclose it. In my opinion, Section 32 deprives the defendant of a limitation defence in two situations: where he takes active steps to conceal his own breach of duty after he's become aware of it, and where he's guilty of deliberate wrongdoing, conceals or fails to disclose it in circumstances where it's unlikely to be discovered for some time. But it does not deprive a defendant of a limitation defence where he's charged with negligence if being unaware of his error. So one has constant reference throughout the judgment to the need for awareness and knowledge against the background of that debate as to recklessness. And if one goes to 536, one sees similar dicta. This is in the judgment of Lord Scott at paragraph 58. And he starts by saying, the words deliberate commission of a breach of duty, these are clear words of English. I'm reading at H at the bottom of 536. Deliberate commission of a breach of duty is to be contrasted with a commission of a breach of duty which is not deliberate, i.e. a breach of duty which is inadvertent, accidental, unintended. There are a number of adjectives that can be chosen for the purpose of the contrast. And it does not matter which is chosen. Each would exclude a breach of duty that the actor was not aware he was committing. And one has further sentences, if one looks at E on the same page on 537, about 6 lines down from the letter E. If the claimant can show that the defendant knew he was committing a breach of duty or intended to commit the breach of duty, I can discern no difference between the two formulations. Each would constitute, in my opinion, a deliberate commission of a breach of the breach. And then finally, from Cave, paragraph 61, Lord Justice Moritz said in a passage I've cited that in general a person is assumed to know the legal consequences of his actions, and that therefore if an act has been done intentionally, the actor's unawareness of its legal consequences would be immaterial and no defence. The premise is, in my opinion, much too wide to constitute a satisfactory approach to construction of statutory provisions such as 32.2. A person may or may not know that an act of his or an omission to do or say something or other constitutes a breach of tortious or contractual duty. His knowledge or lack of it may well be immaterial to the question of whether a cause of action for which he's liable has accrued to the person injured by the act or omission, but that is no reason at all why Parliament, in prescribing the circumstances in which the person injured by the act or omission can escape from a Limitation Act defence, should not distinguish between the case where the actor knows he is committing a breach of duty and the case where he does not. The clear words of 32.2, deliberate commission of a breach of duty, show that Parliament has made that distinction. So again, we say this is all perfectly clear. It refers to knowledge, actual knowledge. Had they wished to carve out recklessness, they would have done so, given that that had been expressly considered. And if one goes further onto other authorities which deal with this point, they are all of a piece. So Williams and Fanshawe deals with both 32.1b and 32.2. 32.2 is dealt with at page 813. And I'll take these quickly because I'm conscious that your lordships were taken to this before. But if we could look very briefly at page 813 and look at paragraph 9. So at B, at the top of 813, we're in the judgment of Mr. Justice Park in Williams. At B, the subsection required the defendant not just to know what he was doing, but also to know that it was a breach of duty. It did not apply to a negligent breach of duty which the defendant did not realise he was committing. And at 823, paragraph 31, Lord Justice Mance, Cave's case decided that the wording of section 32.2, deliberate commission of a breach of duty, requires the defendant not merely to have intended to do an act which constituted a breach of duty, also to realise that that act involved a breach of duty. It's hard to see how that can be consistent with the concept of recklessness being included. Those words are unequivocal, we say. If one then looks at paragraph 34 over the page 824, so that's page 824, electronic bundle. Paragraph 34, I return to the structure of section 32 with this assistance. Deliberate commission of a breach of duty involves knowledge of wrongdoing. So again, the language is clear. I'm going to come back to Williams in a minute to deal briefly with 32.1b, but I'm looking at the moment at the dicta that we have on 32.2. If one then goes on to two cases which are best seen on page 87 of your Lordship's bundle. Page 87 is an extract from our written case, and we refer to Grace and Cotonou. And I cite Lord Justice Briggs in the fifth line of my paragraph 47 on page 87. Section 32.2 requires that the defendant be shown to have been aware at the time that what he was doing was a breach of duty. And Mr. Justice Mann in Cotonou, claimant's case would have to be that the defendant knew what he was doing and it was known by him to be a breach of duty. So again, one has reference after reference. In all those cases, there was a debate as to whether or not they could show a deliberate breach. And so once again, if recklessness was enough, one would have expected reference to have been made to the possibility of an alternative claim based on recklessness, but one doesn't see that. One then has Primeo, of course, which is directly on point, and Primeo, we say relevantly, refers to Cave and Williams and makes the point that on the back of those it's clear that recklessness does not suffice. So far, everything is of a piece, that you need actual knowledge and recklessness does not suffice. So what was it that persuaded the Court of Appeal to make a different conclusion, to reach a different conclusion? Well, what they did was A, look at the history, and I'll come to that in a minute, but also in terms of authorities, they put much weight on a line of Lord Justice Mance in relation to 32.1b in the Williams case. And if I can just show you that one sentence, that is at 825 of your bundle. So here we are looking at 32.1b, not 32.2, but it is common ground that the word deliberate should mean the same. And the sentence that attracted the Court of Appeal's attention is the one beginning here in the second line, just by A, of page 825. Here the defendant's solicitor's duty to speak extended not merely to any fact known by him to be relevant to a potential claim against him, but also to any fact known by him to be relevant to the ongoing conduct of the claim against a third party in which he was or was supposed to be conducting on behalf of his client. If a solicitor decides not to disclose any fact falling within either one or two to his client, knowing that it is his duty to do so, or what amounts in law to the same, being reckless as to whether or not it is his duty to do so, then he can in each case be described as having deliberately concealed that fact from his client. Now, it was that sentence that attracted the attention of the Court of Appeal. We say that the most likely explanation of what has happened here is that that is a reference to Derry and Peake in circumstances where that principle is inapposite to the issue which was actually before the court. And I note in that respect that Mr. Smith QC, in the case you heard previously, made the argument in the Primeo case that that's what this is all about. It's all about Derry and Peake, it's said. Now, that does not help for two reasons. The first reason is that Derry and Peake is all about what can constitute fraudulent conduct. And therefore, that brings into play, one might argue, the principles relating to concealed fraud. And that might bring into play, one might say, old cases which touch on the issue of fraud. And one can see that it might have been in Lord Justice Mance's mind at that stage that given that the basis of all of this is concealed fraud, that one is permitted to look at cases such as Derry and Peake. But of course, we say one never gets there in any event because the whole point of the 1980 Act was to do away with the concept of concealed fraud. So we say that that reference is at best a throwback to Derry and Peake which is impermissible in circumstances where the very purpose of reconfiguring Section 32 was to do away with concealed fraud. And it is worth noting in that regard that albeit there is a reference to Sheldon in passing in the judgment of Mr. Justice Park in Williams, you do not see in this judgment the usual debate that you see in many other cases as to whether or not it's permissible to look back at concealed fraud. And therefore, we submit that what may have happened here is Lord Justice Mance may have had an eye on the previous concept of concealed fraud, but not have an eye on the fact that that is precisely what had been jettisoned by the new Act. So that is the first reason why we say Lord Justice Mance's dicta must be read with some circumspection. But the second reason is a more fundamental reason, which is that Derry and Peake deals with an entirely different point. Derry and Peake is all about whether recklessness can, on certain occasions, qualify as fraud. And the idea is this, that if you make a statement recklessly, you do not know whether or not it is true. And therefore, if you assert that it is true, as part of your representation, that is done fraudulently, or can be done fraudulently, because you know that you do not know that it's true. You don't have to know that it's wrong, but you are representing that you know it's true. And hence the principle in Derry and Peake is that on occasions, recklessness can constitute fraud. It is not right to say that recklessness equals knowledge. And therefore, what we say has happened here is A, Lord Justice Mance has had in mind a concept which has been jettisoned, and B, Lord Justice Mance had in mind a concept which, whilst age-old and well-known, is not applicable to the particular scenario. And one perhaps can best see that if I just show you very quickly page 464 of your bundle. You can see, and if we scroll down, please, to paragraph 398, just there. So 398, you can just see what Derry and Peake is all about. This is from the Critty Palm, where the point came up in a different context. Derry and Peake says this is the key passage. First, in order to sustain an action of deceit, there must be proof of fraud, and nothing short of that will suffice. Secondly, fraud is proved when it is shown that a representation has been made knowingly, 2, without belief in its truth, or 3, recklessly, careless whether it be true or false. Although I have treated the second and third as distinct cases, I think the third is but an instance of the second, for one who makes a statement under such circumstances can have no real belief in the truth of what he states. To prevent a false statement from being fraudulent, there must, I think, always be an honest belief in its truth. That is a different point. But we think that is possibly where the sentence has come from, that knowing is the same as being reckless. And it's for those reasons that we say one should not derive much assistance from the dicta of Lord Justice Mance that we've just looked at. On top of that, I should add that, first of all, the dicta is obiter, because it's clear that there was actual knowledge, and that's common ground. Secondly, there is no mention of any argument on that point. And thirdly, neither of the other judges in Williams make any reference at all to recklessness. It is only Lord Justice Mance that refers to that point. So we say that case simply does not assist, my learned friend, and should not have assisted the Court of Appeal. One then turns onto the next case dealing with knowledge and recklessness, we say, which is the Critty Palm. And that was 2 years after Williams. So in batting order, you have Cave, then Williams, then the Critty Palm. And unsurprisingly, all those cases are referred to in the Critty Palm, and the Critty Palm, again, is unequivocal. You need actual knowledge. And actual knowledge is referred to throughout the judgment. Here, there, and everywhere, they refer to a consciousness of the fact that you are under a duty to disclose. So, of course, the Critti Palm is a 32(1)(b) case, but let me just show you very briefly a couple of references in that. And it is significant that in that case they do refer to Cave and Williams, but if one looks at 448, and here we are looking at 32(1)(b), but we are looking at what meaning they give to the word deliberate in the context of 32(1)(b). And you'll see, and this is important to many of the points, including many of those under 32(1)(b), but also 32(2). And at 321, paragraph 321, Lord Justice Ricks says, it appears, therefore, that there must be active and intentional concealment of a fact relevant to a cause of action, or at least the intentional concealment by omission to speak of a fact relevant to cause of action, which the defendant knew himself to be under a duty to disclose. And then over the page at 449, one has Mr. Gazeman's four-part test, and I'll come back to this later, but just note at the moment little 2 of the test at the bottom of 449. Little 2, were Mr. Lucas and Mr. Chalmers aware, if one goes over the page to 450, were they aware of that duty? And that test, that four-part test, is endorsed by Lord Justice Ricks, and he refers to the fact that Lord Justice Buxton also adopts a similar four-part test. And then if one goes, there are many references to the need for knowledge, but if one looks perhaps at 461 briefly, you will see reference there, again in the concept of deliberate concealment. And at 461, paragraph 380, we're now in the judgment of Sir Martin North, just by F on your page, you'll see he refers to the judge's findings. 3 lines from the bottom, I further find that Mr. Lucas and Mr. Chalmers were aware that ITS was under such a duty and that Mr. Lucas and Mr. Chalmers made a deliberate decision not to disclose the retests and the results thereof. That paragraph contains a holding that Mr. Lucas and Mr. Chalmers were under a duty to disclose the retests and results thereof to AIC. It also contains clear and specific findings of the primary facts which are necessary to establish a case within 32(1)(b) of the Act. So again, entirely consistent with the concept that you have to know. 472 of the same case, you have Lord Justice Buxton's summary of the four-part test for 32(1)(b), and that's in paragraph 427 on page 472. That exposition in the judge's application raises the following issues. Was ITS under a duty to reveal the content of the tests, and did ITS knowing of that duty? Again, all of a piece. And then 476, page 476 at paragraph 447, turning therefore to the issue of whether ITS knowingly breached its duty. The judge's conclusion is set out at 425. So all of these cases are consistent that you need knowledge. And we say that, in effect, answers the question. One doesn't even need to get there, of course, because the natural meaning of the words is so clear. But if you need to look at the authorities, we say they are entirely consistent with the concept that knowledge is required and recklessness is insufficient. You then have on top of that Primeo, which I won't take you to, because your lordships are very familiar with that case. So with that language in mind, with the authorities in mind, what about the statutory purpose? Is that somehow inconsistent with the concept that recklessness should be excluded? We say no, and that is because the twin pillars behind 32, section 32, are the need for certainty and the desire to punish improper conduct. And either one of those is entirely consistent with the proposition that actual knowledge is required, but taken together, we say it becomes irresistible. If it must be both certain and sufficient to constitute improper conduct, at that point it becomes all the clearer that you must have actual knowledge. And there are many examples which one could give of cases which it would be very harsh to describe as improper, but in which somebody would be aware of the risk of a breach of duty. And Lord Sales gave the example of a counsel who advises on a particular point. And
one is always aware of the risk that one might be in breach of duty. And my learned friend says, well, there's a difference between knowing a risk that you might be wrong and knowing of a risk that you might be in breach of duty, but I'm not so sure. I'm certainly acutely aware of the fact that I may on occasions be in breach of duty, and hence I have professional indemnity cover, which covers me for that, but does not cover me if I am merely wrong. That is the very purpose of taking out that insurance. And I just give that example just to illustrate the fact that once one opens the door to recklessness, one opens the door to a great number of possible types of conduct which it cannot sensibly have been intended to fall within Section 32.2. You have to then ask yourself this question, well, how then are the courts to deal with this? If only some reckless breaches are improper and some aren't, how is this to work? Because as a matter of construction, recklessness either suffices or it doesn't. There's no middle ground, and so does my learned friend say this? Well, recklessness suffices, but then there is some sort of discretionary fallback whereby the court can say, well, you were reckless in your breach, but I don't consider it to be sufficiently improper that it justifies attracting the attention of Section 32.2. That just can't work. And therefore we say, again, for the purposes of punishing improper conduct and certainty, there is only one sensible answer, which is that you must know. Furthermore, if one looks at the concept of seeking to bar stale claims and asks oneself, well, how does that fit into this analysis? Again, we say the answer is clear. What Lord Sumption was going on about when he made that point is you shouldn't have to face the allegation in the first place, because it is unfair that you have to dig around to try and meet it many years later for a stale claim. And ask yourself this question: how easy would it be to make an allegation that somebody knew of the risk that they might be in breach of duty? It is surprisingly easy, whereas it is difficult, or more difficult, to plead knowledge. And there are strict rules relating to a plea of knowledge. And that is why it suits the statutory purpose to shut out cases under Section 32.2 which do not involve actual knowledge. It works well for that statutory purpose. On top of all those points, you have the point that recklessness in and of itself is a slippery concept, and I quote, capable of different shades of meaning, presenting problems of definition, and a somewhat tricky concept. And in all those circumstances, we say it simply cannot be consistent with the statutory purpose to include recklessness in the phrase, a deliberate commission of a breach of duty. And my learned friend's answer to that is to say, well, it simply won't catch enough defendants. And we say, so what? It's not meant to catch lots of defendants. It's there to punish improper conduct in a way which is certain and predictable. And so we say, having looked at the language and the authorities and the statutory purpose, it must be right that recklessness is excluded. So, against that background, what about the legislative history and the cases under the old law? Well, we say there is no justification for looking at them at all, and that is because the words are clear. And of course, you can't go back even to a consolidating statute, such as the 1980 Act, if the words are clear. And we rely on the fact that Lord Scott in Cave, and I showed you this earlier, referred to the plain words of statutory requirements. Deliberately concealed and deliberate commission of a breach of duty need no embellishment. These are clear words of English. We agree, with respect, that they are very clear words. And if that's right, one never gets to look at even a consolidating statute. But if one gets to look at a consolidating statute, then one then has to check what it was consolidating. And if it was consolidating prior statutes which amended the law, then you can't go back beyond those which sought to amend the prior law. And of course, that takes you back to the Limitation Amendment Act 1980, which is, quote, an act to amend the law of limitation. Now, on top of all of those points, you have got the clear dicta in Sheldon and Cave to the effect that it cannot be assumed that the law remained the same. And those are perhaps best seen from our written case. If I could show you one reference, which is page 92 of your bundle. You will see reference there to Sheldon and Cave in paragraph 63. And Lord Brown Wilkinson in Sheldon said, in an amending act, all references to concealment by fraud were deleted. And there was substituted the concept of deliberate concealment of relevant facts. This was done deliberately because of the, and this is important, confused effect and misleading terminology. So not only was the language unclear, the effect was unclear of the old equitable doctrine of concealed fraud. In my judgment, it is inconsistent with the plain parliamentary intention lying behind the amendment of an Act of 1939 to continue to construe the Act of 1980 as if it were a statutory enactment of the equitable doctrine of concealed fraud. The Act of 1980 is not. And then Lord Millett in Cave, a defendant was formally unable to take advantage of the Limitation Acts if he'd been guilty of concealed fraud. This was an inapt and inelegant expression which caused much difficulty. It put the emphasis on the fraud rather than the concealment. Section 32(1)b and Section 32(2) of the 1980 Act were designed to clarify and, if necessary, change the law by removing all reference to fraud and substituting the more appropriate concept of deliberate concealment. Such circumstances, reference to the antecedent statute and case law is of limited value, since there can be no assumption that the later statute merely reproduced the pre-existing law. And he makes a point again lower down. It cannot be assumed that the law remained the same. So again, that is very clear from two House of Lords authorities to the fact that you cannot assume it remains the same. So my learned friend is then left with two avenues. One is to say, well, look at the explanatory memorandum. And the explanatory memorandum is a document which appeared at one stage in the process attached to the Limitation Amendment Act 1980. So in other words, the predecessor, or the act which was consolidated into the 1980 Act. And it says there in one paragraph that Clause 7, the relevant paragraph, restates without substantive change the provisions in Section 26 of the Limitation Act 1939. And my learned friend said, well, that provides you with the answer. And we say with respect, no. It all depends how you read the phrase without substantive change, not least because only 10 days before, the point had been made in Parliament that it restated the law, quote, more or less. And furthermore, insofar as it seeks to encapsulate years and years of common law decisions construing an act, it's inevitable that some points will make it through and some points won't. You're construing, or rather you're looking at decisions, supposedly on this hypothesis, from 1939 all the way through. You're not going to get every point in that one sees in these common law authorities relating to the statute. And
is the explanatory memo in question something produced by a government department after the enactment of the bill, or is it something that was before Parliament during its passage? During
its passage, and I'm going to come on to that point because I'm also going to make the point that the version of the bill that was attached to the explanatory memorandum is different. The language is different to the final wording of the Limitation Amendment Act 1980.
So was this a memo produced under the aegis of Parliament for MPs before you say the words were changed?
I think so. I'm afraid I can't tell you what the precise purpose of it was.
My understanding is these documents are normally produced by official departmental officials.
My Lord, I'm unaware of the source, but we say it doesn't matter.
Yeah.
One,
because
it's certainly
not designed for use by the Supreme Court.
My Lord, yes. My Lord, yes. And on top of that, what are you seeking to replicate? Are you seeking to replicate the ratio of previous decisions, or the ratio plus all the obiter of previous decisions? Because we say the ratio is very clear in any event, that actual knowledge is present in all of those cases. And that may be another explanation behind what's going on.
I'm sorry, do you have the bundle reference just to the explanatory?
Yes.
I didn't.
My Lord, so the memo is at 2479, and you'll see there explanatory and financial memorandum. And you will see, if you go on to 2480, and you'll see there, Clause 7 restates, without substantive change, the provisions in Section 26 of the Limitation Act 1939. But importantly, if you then go on in the same document to 2486, you will see that attached to it was a version of the particular provision, which was not the final version, which was in fact made the subject of the Limitation Amendment Act. So if we look at 2486 at the bottom, please, bottom of the page, and you'll see there at item 7 at the bottom. For Section 26 of the Principal Act, there shall be substituted the following section. And then you have 26(1)(a) and (b), you'll see is in a different shape entirely to how it ended up. The action is based on the fraud of the defendant. You're still looking at fraud. The action is for relief of the consequences of a mistake. And then if one goes over the page to 2487 and looks at the top, you'll see that furthermore, at this stage of the analysis, there is a catch-all in 2 little b at the top, that it would be unjust in view of the defendant's conduct to allow him to rely for his defence on the expiry of the period of limitation otherwise prescribed by this Act. So you do have something which is in a different shape in any event. And whilst it's true that the language in little 3 underneath does not change, you can see that on the page in front of you, between that and the final version, you have a very different balance in the nature of the provision. And indeed, once they decide, and it was Lord Mishcon, I think, who proposed an amendment in relation to the need for it to be unjust, that was eventually jettisoned. And I'll come back to that point in a minute. But the point is a short one, that the version of the bill which was attached to the explanatory memorandum upon which my learned friend relies was not the final version. It is significantly, we say, different. Then my learned friend says, well, what about the parliamentary comments by individuals in Parliament, Lord Hailsham and others? We say they are at best equivocal, they are to be read in context, and furthermore, they are not directed to the very issue. And that's important, because if one goes back to Lord Bridge in Pepper and Hart, you may only look at statements made by the promoter of the legislation if it is a clear statement directed to the very issue. And indeed, in the case of R on the application of the project for the registration of children as British citizens versus the Secretary of State for the Home Department, which is a case in which Lord Hodge was involved, he summarised the 3 conditions which are necessary for you to be able to refer to parliamentary statements. And one of those is that, and I quote, the statement must be clear and unequivocal on the point of interpretation which the court is considering. And that is not this case. And of course, the other ones, one of which isn't met in any event, is that the legislative provision must be ambiguous, obscure, or on a conventional interpretation lead to absurdity. So one doesn't get over either that one, which is number 1, or number 3, which is it must be clear and unequivocal on the specific point. And number 2 is that it must be included in 1 or more statements by a minister or other promoter of the bill.
So none of the Pepper and Hart criteria are met?
Well, certainly not numbers 1 and 3. That then leaves the mystery of why the word recklessness was removed from the draft suggested by the Law Commission. And we say in many ways we don't need to answer this question, but the most unlikely answer is that they decided that the word reckless was included impliedly in the word deliberate. That is precisely what you would not imagine to be the answer. And I pray in aid again of Lord Hamblin, saying that the natural meaning of the word does not include recklessness. And as to what in fact happened, we say much more likely is that having included the word recklessness in an original draft by the Law Commission, they decided that that did not, in fact, fit the fact pattern of the actual cases, which all involved actual knowledge. Or indeed, they could have taken the view that that was too slippery a concept and therefore impinged on the principle of clarity and certainty. Or indeed, they may have thought that a trade-off was sensible. If you remove the need for it to be for a residual discretion, then you make it harder to get across the line in the first place by making deliberate something which one construes more narrowly. But I am speculating, of course, and I am doing precisely the sort of exercise, my lords, which we say you shouldn't do. And that is the nature of the speculation. But the least likely explanation is that someone said, aha, well, deliberate includes recklessness, because it doesn't, as a matter of ordinary language. And if that was the explanation, one would certainly have expected to see an analysis and discussion of that point in Parliament. So we say one should not look back at these prior cases. There's no confusion at all in what the language means. In any event, you can't assume the law was meant to be the same. And even if you do go back to look at those prior cases, we say they don't show that recklessness was in fact sufficient if one looks at the facts of the cases and looks at the fact pattern. And I'm not going to go through the authorities, we deal with them all in our case, saying that they're all cases of actual knowledge. And so for all those reasons, we say it simply makes no sense to look back. And just by way of a big picture point, the whole purpose of the 1980 Act was to do away with the concept of concealed fraud. And it seems completely counterintuitive in those circumstances to start dragging the court back through the prior cases, parliamentary statements, and all the rest of it. So that is my case in a nutshell on 32.2. And I've been through language, authorities, statutory purpose, and prior legislation. My learned friend has a fallback argument I mentioned at the beginning, which we say is merely repackaging the point in similar, the recklessness point, but changing the language a little. And we say that essentially, rather than recklessness, which is this test, the defendant must know that there is a risk that his conduct is a legal wrong. It's repackaged as this. The new test, the defendant must know that his conduct has exposed him to a possible claim, which we say is dancing on the head of a pin and is exactly the same concept dressed up as something else in order to sidestep a finding that recklessness is not sufficient. And my learned friend is very candid about that and says in his skeleton argument that, and I quote, looked at in this way, the defendant's mens rea is not a matter of recklessness. So we say it's a results-driven argument, which simply dresses up the point as something else, and that one cannot get away from the fact that you need actual knowledge of the breach, and it has been rightly conceded that my clients did not have actual knowledge of the breach, and nor were they willfully blind. And however one dresses up the test, one cannot cross that threshold, and that is the end of it, we say, in relation to 32.2. And I've dealt with that quite quickly, and I can pick up any further points on the alternative way it's put in reply, but we also take the point that the other way, the new way it's put, is inconsistent with the language, it's inconsistent with the authorities. You have authority after authority which refers to the need to be aware that what you are doing is a breach of duty. And my learned friend would somehow have to tiptoe through those, which we say he cannot do. So, my lords, that is 32.2. I want to move on now to 32.1b and start with what we describe as the conventional analysis. And I say conventional because we do say that until the Court of Appeal's judgment in this case, the law on 32.1b was neat and well settled. And I describe that as the conventional analysis. And if we could just look at that analysis, you can see it in 3 or 4 paragraphs in various authorities, some of which we've looked at briefly already. But if one looks at page 448, please,
and apologies because you have already seen this, but in a different context. And I think it is worth understanding the genesis of what I call the conventional approach. So 448 is Lord Justice Ricks in the Critty Palm. And we are dealing with section 32(1)b, the precise provision. And he says at 321, it appears, therefore, there must be either active and intentional concealment of a fact relevant to a cause of action, or at least the intentional concealment by omission to speak of a fact relevant to a cause of action which the defendant knew himself to be under a duty to disclose. There is no decision that anything less than a duty to disclose will suffice in the absence of active concealment. So that's your starting point for 32(1)b. Over the page at 449, and we looked at this again before, you have a four-part test for 32(1)b. And my submission will be, my lords, that this is a thoroughly sensible, neat, and workable test. Number one, at 326 at the bottom, did ITS owe a duty to disclose the relevant information? And I'll come on to show you that that was obviously a reference to a legal duty. 2, were Mr. Lucas and Mr. Chalmers aware of that duty? 3, did Mr. Lucas and Mr. Chalmers take a deliberate decision in spite of their knowledge of ITS's duty not to disclose the relevant information? 4, was the information relevant to AIC's right of action? A simple, workable, four-part test. Now, you'll see underneath Lord Justice Ricks says, in his judgment below, Lord Justice Buxton adopts the 3 tests which essentially cover the same ground. And if one goes to page 455, sorry, that's a wrong reference. 472, apologies. You can see Lord Justice Buxton's exposition of the four-part test. He puts it in 3 questions, but again, it's very clear. Was ITS under a duty to AIC to reveal the existence and content of the Cooper retest? Did ITS, knowing of that duty, decide not to reveal the existence and content of the Cooper retest? Were the Cooper retests relevant to any, and if so, which of the rights of action asserted by ARC that are otherwise statute barred? So we say a very nice, simple test, which is broken down into constituent parts. If one then goes from there to...
Sorry, just on the strict matter of authority, Sir Martin Norse, did he agree with
Lord Justice Buxton?
With Buxton.
My lord, so one gets that. I'm not sure if whether your lordships were taken to this previously. I can explain a little bit more about the case if required, but look, Sir Martin Norse agreed with Lord Justice Buxton. And I'll take you through these judgments in more detail later because I want to make the point, and it will take me a few minutes, that it is absolutely clear when one reads this judgment that it is a reference to a legal duty. I will come back to that, but at the moment I'm just trying to show your lordships the classic conventional approach whereby one puts together these series of questions to get the answer to the question under 32(1)b. And Mr. Justice Andrew Jones QC in Primeo at first instance, if one looks at that very briefly, 2165, and you'll see at paragraph 306, he starts by looking at the 4 allegedly positive acts of concealment relied on by the plaintiff. So there, he's looking at what I called vanilla positive act concealment, the first part of an analysis under 32(1)b. So he does the classic analysis of looking at positive acts first, and this is misrepresentations and the like. And he says there were none of those. So he then moves from positive act concealment to paragraph 307, which is just over the page. And he then says, for the purposes of 37(1)b, which is the same provision, there are 4 elements to proving concealment by omission. It must be established that 1, the defendant was under a duty to inform the plaintiff of the facts in question. 2, the defendant knew it had such a duty. 3, knowing of its duty, the defendant nevertheless decided not to reveal facts in question to the plaintiff. And 4, that the facts in question were relevant to the plaintiff's cause of action. And if you look underneath, just in passing, you can see from about 15 lines down
that he then asks whether, if you look 4 lines from the bottom of 307, he then asks whether the evidence shows that the relevant individuals did not consider that they had any legal duty to share their opinions and risk management assessments. It's quite obvious from this judgment that he is assuming that you must have a legal duty. And the same approach is taken by the Court of Appeal. If we can look very briefly at page 987 of your bundles, and if we look at paragraph 444 at the bottom there, clear, and I do rely on this, in that they have looked at, again, Cave, Williams, the Critty Palm, and they say clear and authoritative guidance as to a number of the principles applicable to sections 37(1)A and B and 37(2) can be found in decisions on the identically worded sections of 32(1)A and B and 32(2) of the 1980 Act. And they then refer to Cave, AIC, and then we derive the following propositions from these decisions. If one scrolls down, you can see the defendant must be under a duty to inform the plaintiff of the facts in question. The defendant must know that it had such a duty. Knowing of its duty, the defendant nevertheless decided not to reveal the facts in question to the plaintiff and to breach the duty. The facts in question are relevant to the plaintiff's cause of action in the sense that they are facts without which the cause of action is incomplete. And then paragraph 5 needn't concern us. It's a point arising out of Arcadia.
Now, those are observations, I think, relating to a situation where there's an omission to reveal rather than active concealment.
Indeed. And I've drawn that distinction because the 4-part test that we've been looking at is all about omissions, a failure to disclose something. In a different category entirely is the positive act concealment. That's different. So this is all in the non-disclosure context. And we then have Mr. Justice J at first instance, who looks at the Critty Palm and looks at Primeo and says, well, this is all very straightforward. You need a legal duty. And we say he's absolutely right. And we needn't turn it up, but this was Mr. Justice J in this very case. Paragraphs 32 to 35, just for your note, is at 238. And he says you need a legal duty. See the Critty Palm. There was no legal duty in this case, and hence found against my learned friend's clients on 32(1)B, and we says he was absolutely right to do that. Now, that is the classic conventional analysis. And we say it makes perfect sense for reasons I'll come on to explain. It's neat and tidy and asks the right questions. And then one has the judgment of the Court of Appeal, where what happens is that neat test becomes subject to the addition of various words. So if one looks at 225 of your bundles, you will see Lord Justice Mayles in the Court of Appeal. And he tweaks the analysis in such a way as to include a non-legal duty and to include recklessness. So if one looks at 199, and this is perhaps the neatest way in some ways of identifying the differences between myself and my learned friend. So bearing in mind the conventional analysis, one turns to 199. We are required to ask a series of questions, he says. 1, whether this was a case of active concealment or mere non-disclosure. We agree. This is not a case of active concealment or positive act concealment. This is non-disclosure. 2, if the latter, whether the bank was under a duty to disclose the commission. So far, so good. But then we have the words, either as an independent duty or as a duty in Limitation Act terms. Those words are not part of the conventional analysis. And those are the words which were added by the Court of Appeal, and we say where they went wrong. And they wrongly construed the Critty Palm to be saying that a moral stroke utilitarian style duty sufficed. So the first words that we would invite your lordships to draw a line through are the words either as an independent duty or as a duty in Limitation Act terms. And we then continue, item 3, whether the bank knew that, so far so good, but here are the new words,
or was reckless whether, in brackets. We say those must be struck through. They are not part of the jurisprudence in this area, and they cause all sorts of problems for reasons I'll come on to explain. Whether the bank knew or was reckless whether it was in breach of that duty. And we then have and 5, just to be clear, there isn't a 4, and I will continue to refer to it as 5, but 5 is an additional element, whether the bank knew that or was reckless whether the commission was relevant to a right of action of the claimant. Now that is the one point that we agree with Lord Justice Mayles on, that there is an additional requirement, albeit we don't accept the words or was reckless whether in that 5th point. So just to be clear, our case is that that analysis is correct, save that you delete the words either as an independent duty or as a limitation or as a duty and limitation act terms, and delete the words or was reckless whether. Now, just to put the point 5 in context, the point 5 is what I call the lazy solicitor point. And this arises out of the judgment of Lord Justice Mance in Williams. And he says, well, what happens in this scenario? You are working your way through these questions, and you have a duty, because the solicitor is under a duty to tell his client something. He decides that instead of telling him that, so he is under a legal duty, he's going to go on holiday. And it happens, it so transpires that that fact was relevant to a cause of action against him. But he didn't know that at the time. So at the time that he goes on holiday and does not make the disclosure, he's under a duty, he knows he's under a duty, and he knows that he's in breach of that duty. But do you need the additional element of knowing that the fact is relevant to a cause of action against you? Now, that is the one point which was left open in Williams by Lord Justice Mance, although he appears to have been firmly of the view that you should have to know that. Now, in many ways, my lords, one does not need to get to this point, because, for reasons I'll explain, we say we win on the basis of items 2 and 3 of Lord Justice Mayles' analysis, in that we say you need a legal duty and you need to know that you are under a legal duty. So if I'm right on the deletions that I make to item 2 and item 3 of that test, then we say we win because my learned friend cannot show knowledge, or indeed willful blindness, of the existence of the duty. But insofar as I need to, I also pray in aid of item 5, and I say the Court of Appeal were right on that point, to say that you have to have that additional element in play, and it is an additional element. I'll come back to that later, because there are parts of my learned friend's submissions where he seems to suggest that items 3 and items 5 are alternatives, which we say is quite wrong.
But unqualified by the reckless whether.
Correct.
Yeah.
My Lord, so that is the conventional analysis and the way in which it has been, we say, tweaked by the Court of Appeal, and with respect, we say wrongly. And against that background, I'm going to try and answer 7 questions for you, which I hope will assist you. The first arises out of Lord Justice Mayles' second point, and that is whether it is right that a utility or morality type duty will suffice, or whether you need a legal duty. And then I'm going to address my learned friend's fallback argument is, well, do you need a duty at all in the context of concealment? And we say, well, that's certainly far-reaching, and we'll deal with that secondly. Thirdly, the question arising out of Lord Justice Mayles' question 3, was he right to add the words or reckless? And in some ways, that's a point I've already dealt with, because I took you to the authorities on section 32(1)b and the meaning of the word deliberate. And we looked at Williams and we looked at the Critty Palm. And constantly there are references to the need to know. And so that's the third question. The fourth point is, should the Supreme Court make a new finding of positive act concealment?
we say not open to my learned friend and wrong. And if I'm right thus far on those 4 points, we say that's the end of the appeal. If I'm wrong on one or other of those points, there are then potentially 3 other points which arise, which are my 5th, 6th, and 7th, and they are these. The 5th is one arising out of Lord Justice Males's second question. Was CSO in fact under a legal duty to disclose at all? We say we never get there because it's so obvious that even if they were under one, they didn't know it, and there is a finding that they didn't know it, that one doesn't need to get there. But if you do need to get there, we say, well, they weren't under a duty, and that's exactly what Mr. Justice Jay found, and that hasn't been appealed. That point, we say, stands. There was no legal duty. The 6th point which arises is what I call the lazy solicitor point, and I'll touch on that. And then the 7th and final point which arises is my learned friend's new argument right based on non-disclosure after Plevin was handed down in 2014. So the idea then, for that final point, is that even though the relationship came to an end in 2010, somehow my clients become under a new duty of some kind, and they concede it cannot be a legal duty because the legal obligations cease at the end of the relationship in 2010. So it has to be premised on some kind of non-legal duty emerging when Plevin is handed down in 2014, and we say it's riddled with difficulties. But, my lords, if I can start by focusing on what we see as the key issue, and that is a legal duty required or is a utilitarian or moral duty sufficient? And we say that, first of all, addressing that as a matter of language, there is no difficulty in finding the requirement for a duty in the concept of concealment. And I'm not sure I can put it much better than looking at page 102 of the bundle. And at page 102 of the bundle, you'll see this is our written case. And when dealing with the linguistic point, we say in paragraph 90 at the top, in this regard, in the absence of a duty to speak, it is hard to see how silence can qualify as concealment. And hence the Court of Appeal itself recognised that inherent in the concept of concealing something is the existence of some obligation to disclose it. This echoes the words of Lord Justice Manson Williams. The underlying thinking would seem to be that mere non-disclosure in the absence of any duty to speak may be deliberate but cannot constitute concealment. So we say that is the basis of a linguistic language argument to the effect that one needs a legal duty in the case of a non-disclosure. Now, turning then to the authorities, and here we say the position is particularly clear, which you may say is ironic given that this is the point we lost on before the Court of Appeal. But we do say the Critti Palm is very clear on this point. And in fact, one needs to go back as far as Williams to see the genesis of the principle in the Critti Palm that a legal requirement is required. If one looks at page 103 of the bundle, you will see in our written case a reference to Williams and Fanshawe. And rather than turn it up, if I could just draw your attention to the citation in the second line of my paragraph 98. Lord Justice Mance explained that a solicitor who intentionally withholds from his client a fact about which he knows he ought to inform him or her can readily be said to conceal it. But in many cases, there may be no running relationship, and even where there is, it may not involve any general legal duty to inform the other party of the relevant facts. On the face of it, concealment in such a context might seem to require active conduct rather than a mere decision to stay silent, even in circumstances where it would be normal or moral to speak. And he added, the underlying thinking of Lord Millett was that mere non-disclosure in the absence of a duty to speak may be deliberate but cannot constitute concealment. But there you can see what he's saying is you need a legal duty. It is not enough to say that it would be normal or moral to speak. And that is precisely where we have, in fact, ended up, by reference to a utilitarian stroke moral concept of duty. So Williams is the first case to look at, and one then comes on to the Critti Palm. And my learned friend, understandably, decides not to engage much with this in his written case and says instead, well, you must look at this afresh. As you're the Supreme Court, you're not bound. But we do say that it is very important to look at the Critti Palm and look at what their lordships were saying, because they deal with this point quite carefully. And it is obvious, we say, that a legal duty is required. We have all three of the judges in that case, we say, referring to a legal duty. We have a number of judges since that case who have looked at the Critti Palm and who have all said the ratio of this case is to be found in the judgment of Lord Justice Ricks at the relevant paragraph, which we rely on. Nobody has ever suggested in any case, authority, text, commentary, article, anywhere, that the Critti Palm said that a moral/utilitarian duty is sufficient. And that is because it's plainly wrong. And we refer to Mr. Justice Stuart Smith, an Australian judge, and then all those involved in Primeo, who take the same view based on the Critti Palm. So it's just worth turning to that briefly now. And if I can just show you why we say the Court of Appeal got this wrong. And it's best to start at 373 of the bundle, which is the head note. And what we are looking at here, just to be clear, is references to whether or not we need a legal duty. And of course, you'll no doubt recall that Lord Justice Ricks says, A, you need a legal duty, and that's not in dispute, that Lord Justice Ricks found the need for a legal duty, and B, there was none, because you cannot imply a term, which is what the judge had done. So the two things that aren't in dispute is that the judge had considered that it was necessary to find a legal duty, and he found one. And two, that Lord Justice Ricks found that it was necessary to find a legal duty, and there was not one. And we say that the difference between Lord Justice Ricks and Lord Justice Buxton and Sir William North lay in the fact that they thought you could fashion an implied legal duty, an implied term, out of considerations of common sense. And so they said, because it's so obvious that you have to correct the fact that your original certificate was wrong, we're going to imply a term. And that's what I'm going to seek to show you as I take you through a few of the passages in this case. And so if we look first of all at 373 and look at item 2, Lord Justice Ricks dissenting, the defendant had been under a duty to disclose the existence and content of the Cooper retest. The existence of the duty was a matter of common sense. The accuracy of the statements of quality on the certificate was of importance to the claimant and the buyers as a matter of law. And that's critical. As a matter of law and commercial sense, it challenged reality to think that a certifier, armed with retests that suggested the tests used to complete the certificate had or might have produced incorrect results, could nonetheless simply do nothing about it. So Mr. Justice Jay, we say, got this absolutely right, in that he said that the references to the common sense of the point were simply references to the common sense which Lord Justice Buxton and Sir William North used as the premise for their implied term. Commercial considerations came into play in assessing whether or not to imply a term, meaning a legal duty. So if one then goes to page 387, and you will see at 387 there is a reference to some questions asked by the judge below, Mr. Justice Cresswell. And at paragraph 51, Lord Justice Ricks says this: the judge posed the agreed issue, and issue 2, was ITS retained by Mobil and AIC in any kind of advisory capacity? What was the proper scope of the contractual duties owed by ITS to AIC? It's not here clear how the judge answered the first of those questions, but he stated his answer to the second of them in the following terms, and he then identifies a number of contractual duties, which he says arose, and they included at little 8, in effect, correcting errors. So that is the source of the judge's implied term. And in 52, over the page at 388, Lord Justice Ricks says, in drawing out these implied obligations, the judge had primary regard to international and ITS internal guidelines, to which I refer below. Suffice it to say, at present there is a dispute as to whether the judge had regard to the applicable guidelines. ITS says he did not and has erred accordingly. To some extent, the judge supported his implied obligations by reference to admissions made by ITS's principal witnesses, to which I will also refer to below. Mr. Hamblin accepts that the judge's implied obligations are at the cutting edge of the law. And that is all that was pleaded, as I'll come on to show you. These implied obligations were at the cutting edge of the law. Mr. Hamblin is not saying, I don't need a legal duty. A moral duty will do. A utilitarian duty will do. He is arguing about implied terms which he accepts are at the cutting edge of the law. And no other authority has stated an inspecting house's duties in these details before. If one then goes on to page 413, and one can see there further analysis by Lord Justice Ricks at paragraph 186 at the bottom of 413. The judge clearly built his implied obligations, set out at 192 and referred to at 51, that's what we've just looked at, on the model of NAMAS standards. Those are applicable industry standards. He cites no other basis for obligations which he finds to have existed. And then over the page, on page 414 at the top, paragraph 192 comes immediately after his citation from those documents. He said at 186 that the best guide to what is comprised in the duty owed by an inspection agency, whether in contract or tort, to take reasonable care to ensure that any certificate issued is accurate as to the matters on which it is instructed to report, is found in the international standards. He then proceeded to quote extensively from NAMAS. He said NAMAS applied, etc. And then finally, he immediately went on to conclude that ITS's implied obligations to both Mobile and AIC included all those obligations set out. So again, he's referring to the legal duties. And just in passing, you'll see from what we've read so far already that there were references to legal duties arising in contract and in tort. And that is important because later on there is a remark of Lord Justice Buxton, I think, who says that it was wrong to define the question in terms of contractual duties, and the word contractual is italicized. And the Court of Appeal said, well, that meant that was a nod to non-legal duties, but it's a nod to tortious duties, and the fact that they had stated the premise too narrowly by referring to any contractual duties in the question which the judge asked. And you'll recall, we looked in paragraph 51, and he said, what were the contractual duties? All that the judge is saying is that's too narrow. He's not saying it's a non-legal duty which arises. He's simply identifying the fact that it's more than contractual. I'll come back to that in a minute. And then if one goes to 446, and we're still within Lord Justice Ricks, paragraph 310 on page 446, as it is, how did the judge put his finding of deliberate concealment? Earlier in his judgment, the judge had held that ITS owed a legal duty to AIC to inform it about the fact of the Cooper retest and its results in answer to trial issues 21 and 22. You then go on to paragraph, page 448, and there you have the paragraph we've looked at twice already, and I'll just draw your attention to it in passing, 321. And that is the paragraph which you see judges in other cases refer to as containing the ratio of the Critti palm. And that is obviously a reference to the legal duties that Lord Justice Ricks is referring to, and you'll see that mentioned time and again. And over the page at 449, we looked at Mr. Gazeman's neat encapsulation of the conventional analysis, and then over the page at 450, we have precisely the point which the Court of Appeal accepted being rejected by Lord Justice Ricks. And there you have Mr. Hamblin, with all his skill and dexterity, submitting that there was no need for an ingredient of a legal duty. That was the point he was making. He ran that precise point. He contended that it would have been sufficient if the relevant facts would have been disclosed in the ordinary course of the relationship between the parties, citing the dictum of Part J in Williams. And he then says, no, that's wrong. As I understand the analysis of Brooke and Mance in Williams, what is needed is either a duty to disclose or a conscious omission to disclose, or at least active concealment. AIC is not alleged active concealment. Indeed, AIG's pleading, and this is important, pleading of deliberate concealment, which is brief, appears to be essentially premised on pleadings in the statement of claim which assert duties of disclosure as a matter of law or contract. So the only pleaded duties in this case were legal duties. There wasn't even a pleaded case of a utilitarian stroke moral judgment. And in 330 underneath, as for a duty to disclose, the judge found that such a duty existed, founding himself on the main in the NAMAS guidelines and ICS's internal guidelines, but also referring to passages in Mr. Lucas and Mr. Chalmers' evidence, where they accepted that they should have informed AIC of the test and its results. I would refer, however, to various paragraphs. And then at G, in my judgment, these are in themselves an unsatisfactory basis upon which to find the existence of legal duties of disclosure. And then at the bottom of that page, the final 3 lines, the process is governed by contract. Duties of care are implied in this contract, but as a matter of classic legal analysis, go no wider than is required by law or business necessity. Any duty of disclosure will similarly need to be explicable as an implied term required by business necessity or law. In such a context, what duties of disclosure are required? So there is absolutely no doubt that Lord Justice Ricks considers that this is all about the only pleaded allegation, which is legal duties. And what he then does is analyse whether or not it is possible to imply a term. And one starts at 452 in paragraph 340 at the bottom of the page. My intuitive understanding of the situation, therefore, does not encompass an implied term on an inspection house to disclose any private test it makes on residues on the goods in question, or the results of the test. A fortiori, not in circumstances where there are no valid certificates, has been issued and it's too late. What then could be the basis for an implied term such as that found by the judge? In such circumstances, what arguments have been or could be deployed to suggest otherwise? So now this is important because he is now going to go on and explain what he thinks Lord Justice Buxton is finding. And I make the forensic point that, as you'll see in a minute, Lord Justice Ricks says Lord Justice Buxton has found an implied term based on utility and morality. And I disagree with him. And we then come on to Lord Justice Buxton later, and you do not see Lord Justice Buxton saying, Lord Justice Ricks has completely misconstrued my analysis. I'm not implying a term. This is a special duty based on utility and morality. On the contrary, Lord Justice Buxton gives a nod in his judgment to what Lord Justice Ricks has ostensibly said he is saying. And I'll come on to this in a minute. But you'll see, so at 453, what Lord Justice Ricks then is start identifying the various grounds for implying a term. And if one looks at 344 on page 453, you see the source of utility and morality. And in some ways, the irony is that Lord Justice Ricks is using those words in a somewhat disparaging way, along the lines of, you cannot imply terms based on utility and morality. That's his point. So you'll see in 344, a second possibility, therefore, is that utility and morality might combine. Now, that is exactly what the Court of Appeal have found, a combination of utility and morality. To suggest that when once any issue about a certificate has been identified, the certifier of a possible inaccurate certificate owes a duty to investigate and report, not because the original certificate can be changed or substituted, but simply to throw further light on the question mark that has been raised. Now, this is a contemplation of a legal implied term. And he says at 345 at the bottom, this is an important argument.
It is floating silently in the background, but has not been clearly articulated, for the term, implied term, which the judge has derived has been obtained from the international and internal guidelines and or from evidence from the witnesses as to what should be done without any particular analysis. Nevertheless, Buxton LJ, in a powerful passage in his judgment centred at 439, has, I think, adopted it, stating that the converse challenges reality. It is important because if it is correct, it is in theory applicable to every conceivable type of contract. So what Lord Justice Ricks is saying is Lord Justice Buxton has found an implied term based on utility and morality, and I disagree with him, not least because it's in theory applicable to every conceivable type of contract. So one then goes on to consider, Lord Justice Ricks then goes on to consider various other ways in which the point is put. And then at 456, he then says, so, electronic bundling 456, in paragraph 351, in sum, I do not think that there was a contractual duty of disclosure. In effect, AIC has pleaded, and again I take the pleading point, pleaded such parasitic implied duties in a number of different ways, in essence because it was conscious that a breach of the underlying causes of action were and were in danger of becoming time-barred in the absence of deceit or fraudulent suppression. And then just in passing, you'll see at little f underneath a reference to the fact that allegations were made in both, and in little b, just underneath f, negligence or breach of contract. So again, that makes the point that this was not just a contractual analysis. One then goes on to Sir Martin Norse at 461. And he says at paragraph 383 on page 461, electronic bundling numbers, at the bottom of that page, as to the duty of disclosure, I am in general agreement with the reasoning of Buxton LJ expressed at 428 to 443. For myself, I would be content to base the existence of the duty on the simple common sense of the notion that a certifier who has acquired knowledge of a material inaccuracy in his certificate is obliged, using the language of legal obligation, is obliged to disclose it. See 439 and 440. If one then goes on to Lord Justice Buxton, the easiest way of seeing what is happening is to look at 471. And at 471, what Lord Justice Buxton says is, let's look at Park J's alternative way of putting the point. In other words, you don't need a legal duty. In Williams, let's look at that. And he says at G on 471, in Williams's case, Park J said, the requirement is that a fact must be deliberately concealed. It is, I think, plain for concealment to be deliberate. The defendant must have considered whether to inform the claimant of the fact, decided not to. I would go further and accept that the fact which he decides not to disclose either must be one which is his duty to disclose, or at least must be one which he would ordinarily have disclosed in the normal course of his relationship with the claimant, but in the case of which he consciously decided to depart. So what's happening there is that is a nod to the very argument which Lord Hamlin had been making to Lord Justice Ricks, and Lord Justice Ricks had refused. He said, no, that's wrong. And then Lord Justice Buxton accepts that. And at J, the last part of that statement, with its reference to disclosure in the ordinary course of duty, is controversial. But the narrower test of breach of duty was endorsed in the same case by Lord Justice Brooke. So in other words, you need a legal duty. That's the narrower case. The claimant did not know a fact relevant to her cause of action until a date less than 6 years before this action was brought. And the reason why she did not know was that Miss Brown intentionally concealed from her when he was under a duty to tell her about it. The facts appear to me to fall within the compass of Lord Scott of Foscott's exposition of the effect of 32(1)b. And then he says over the page at 472, in paragraph 427, that exposition and the judge's application of it raises the following issues for this court. Was ITS under a duty to AIC to reveal the existence and content of the Cooper retest? Now, he has expressly said that he is basing that upon the narrower interpretation, which is a legal duty. He has expressly identified the fact that any wider proposition is controversial. And that is consistent with the findings of Lord Justice Ricks earlier in the judgment that the dicta of Park J was not proper authority for any proposition that anything less than a legal duty would suffice. You then move on to 472, paragraph 429. And I raise this simply because this is a point the Court of Appeal prayed in aid of. At 429, 3 lines from the bottom, Lord Justice Buxton says this: the question that the judge was asked in issue 2, was ITS retained by Mobil and AIC in any kind of advisory capacity? What was the proper scope of the contractual duties owed by ITS to AIC? That question was not framed in terms that are helpful in the inquiry under the Act. The issue there, and in this case, is not whether ITS acted in an advisory capacity to Mobil and AIC, because plainly, apart from its obligations as certifier, it did not do so. Nor is the question of whether, in the terms of the Act, ITS had a duty to reveal the Cooper retest necessarily determined by reference to its contractual duties. And the Court of Appeal said, well, that's a nod to non-legal duties. We say, no, that's a nod to tortious duties. The other duties that we've seen reference to on numerous occasions earlier in the judgment. And it's to read much too much into the italicization of the word contractual to suggest that this somehow triggers some kind of moral utilitarian non-legal duty. If you then go on to 474, he then says at paragraph 438 on page 474, it follows from what I've already said that I cannot with deference accept Lord Justice Ricks's dismissal of these admissions by ITS as having been made on certain factual hypothesis or subject to hindsight or qualifications. See 330 above. Again, cross-referencing to Lord Justice Ricks's judgment. Now, again, pausing there, it is inconceivable that Lord Justice Buxton would not have said at this point in time, when he's cross-referring to Lord Justice Ricks's judgment, by the way, I totally disagree with Lord Justice Ricks that you need a legal duty, and he has summarised my finding incorrectly. I'm not saying legal duty, I'm saying moral duty. It's inconceivable that that would not have been pointed out at this stage. He has read Lord Justice Ricks's analysis. He then continues, the hypothesis were in fact states of affairs that the judge found to have been proved, and the statements were not accidental or thoughtless, but considered assertions by senior and experienced men in the industry. Not only was the duty to disclose the Cooper retest acknowledged by ITS, but also the existence of such a duty as a matter of common sense. We've seen the unchallenged evidence of AIC as to the importance of them, of the accuracy of the statements of quality on the certificate. The judge also stressed, and no one suggested he was wrong, the importance of the accuracy. I've just gone over the page to the top of 475. The importance of the accuracy of a certificate to buyers and sub-buyers. And then here, this is critical, not only as a matter of law. That is the point. He is recognizing that it is a legal duty that is required, but also commercially. It really challenges reality to think that a certifier, armed with tests that suggest the test to complete the certificate had or might have produced incorrect results, could nonetheless simply do nothing about it, and in particular could properly say nothing about those tests to those who employed him to certify. That obligation, again using the language of obligation. And he then says at C underneath, nor does such a duty create a continuing duty of review and disclosure under every conceivable kind of contract. This is the specific case of a certificate where the certifier was in possession of material of his own creation that cast doubt on the certificate that he'd given. To hold as I would that he was under a duty in Limitation Act terms to reveal that material does not open any floodgate into any other kind of relationship. So there all he's saying is this is an implied term implied on the particular facts of this case. And the Court of Appeal says, the fact that he refers to, quote, Limitation Act duty means it's a reference to a non-legal duty. And we say that is obviously wrong. Everybody was dealing with implied terms. The pleading was of an implied term. The judge found for an implied term. Lord Justice Ricks found for an implied term. Lord Justice Ricks identified Lord Justice Buxton's decision as being based on an implied term. And therefore, these are scant morsels, with respect, on which to make a finding that something short of a legal duty will suffice. And really, the reference to Limitation Act terms is simply a reference to the fact that this arises in the context of the Limitation Act. And you see that from 443 underneath. I am therefore satisfied that in the sense relevant to the Act interpreted in the authorities set out in 426, ITS had a legal duty to reveal to AIC the existence and content of the Cooper retests. And just pausing there, if you look at, that's an important reference, where he says there in 443, I'm therefore satisfied in the sense relevant to the Act interpreted in the authorities set out at 426. Back to 426, that is the passage in which he says that Mr. Justice Park's possible further analysis was controversial, but the narrower test of breach of duty was endorsed in the same case by Lord Justice Brooke. That is where he has discarded rightly the concept of a non-legal duty. So, and then finally, if one goes on to 480, page 480, in 467, Lord Justice Buxton says, I would allow the appeal to the extent only of reversing the judge's findings as to deceit. And that, again, gives you the answer. The judge made a finding of deceit, and that's been reversed by everybody. Nothing else has been touched. And the judge's finding below was that there was an implied term. And it is inconceivable that if Lord Justice Buxton and Sir William Norse had intended to make a finding of a utilitarian moral duty, which differed completely from the pleaded case and the case found by the judge, that they would not have said, I am conscious that I am differing from the judge on this point, and indeed from Lord Justice Ricks, but I do so for the following reasons. And instead, what you have is a reference to a, quote, Limitation Act duty, and a reference to the word contractual being italicized as somehow constituting a finding that a moral utilitarian duty sufficed. And it's for those reasons, my lords, that we do say we were surprised at this particular finding. And it is, of course, important because all that this case does is set out what we say is the conventional analysis for 432(1)(b) cases. And on top of all of those references, which I've shown you already, if you look at the authorities since the Critti Palm, which refer to it, they all refer to the relevant principles, the four-stage test, being derived from the judgment of Lord Justice Ricks. Nobody has ever suggested that Lord Justice Ricks was in fact the minority and that Lord Justice Buxton and Sir William Norse were saying something different and were the majority. And there are cases such as Mr. Justice Stuart Smith in Jalal versus Royal Dutch Shell, where he says there was no legal duty to disclose a particular document, and that's because obligations of disclosure hadn't arisen under the relevant Nigerian court rules. You've got an Australian case where the judge again refers to Lord Justice Ricks's judgment and to the very passages which I took you to as containing the ratio of that case. It has never been suggested by anybody ever in any jurisdiction that we're aware of that this case said anything other than that the conventional 3- or 4-part test, whichever way you look at it, for 32(1)(b) was that to be found in Mr. Gazeman's and Lord Justice Buxton's 4-part test that we see in this case. Now, taking a step back, what about the purpose of section 32(1)(b)? Is it right as a matter of purpose that you should need a legal duty? We say yes. Firstly, because the conduct must, of course, be sufficiently improper. And you get yourself, we say, in all sorts of trouble if you start to introduce utilitarian stroke moral duties. And again, I do hark back to the fact that in contractual negotiations, you will often, if you're selling a horse, a company, whatever it is, there are things which you will not say. And there are things which you will not say because you do not want your contractual counterparty to know about them. But there's nothing wrong with that. And that is because there is a principle of caveat emptor.
silence is golden. If you want warranties, negotiate them. But you don't have to say what you think your counterparty might like to hear or would want to know. And that is a fundamental tenet of English law, and indeed one of the reasons why it's so attractive. And this is important because as soon as one introduces, we say, some kind of moral stroke utilitarian duty to disclose something, you immediately start cutting across that. Because the individual who is negotiating the sale of whatever thinks to himself, well, I know I'm not under a legal duty of any kind here. I don't have to say, let's test it. Let's say you're selling a horse and you know that the horse is allergic to a particular type of hay. Now, you don't have to say that when you are negotiating your contract for the sale of the horse, because silence is golden, caveat emptor. You can't lie, you can't misrepresent, but you don't have to say that. That's basic stuff. But under this new utilitarian moral duty, you think to yourself, well, hold on, maybe I do. And one ends up in a situation, once one starts to introduce concepts such as a utilitarian moral duty into deliberate concealment, that unless you do say everything which you think the other side might be interested in hearing, because it might be relevant to a claim they might have, you're going to be guilty of deliberate concealment. And 20 years down the line, applying a Sheldon approach, you might discover a further fact. So you can test it, you can make it even worse. Let's assume proposition A is you know at the time of the sale that the horse is allergic to a particular type of hay, and you don't say it. Nothing wrong with that. But you might be under a utilitarian or moral duty to say it. Proposition number 2, 20 years later, you discover that that horse was allergic to a particular type of hay. Now, under Sheldon, a combination of Sheldon, which is why 32(1)b is so powerful, and this new utilitarian moral duty to disclose, it might be said, well, you should then call up that buyer 20 years later. And if you don't, that's deliberate concealment. And as soon as you trigger deliberate concealment, the clock goes back to 0 under Sheldon. And it's points such as this which demonstrate how dangerous it is to move away from the strict legal duty. And that is the great sense of the conventional analysis, because they knew that this is all about deliberate intentional wrongdoing. That is what these sections are there to catch. Improper conduct, and they're to do it with certainty. And instead you get a moral utilitarian duty which A, catches far too many people, because you could argue that there is a utilitarian moral duty to disclose the fact that that horse is allergic to a particular type of hay. And of course, I don't need to reiterate the fact that there are no duties of disclosure under English law, save in very limited circumstances. And just for your reference, Lord Justice Ricks makes this point very clear in the Critty Palm at page 454 of your bundles at paragraph 345. He says, there is no general principle of disclosure. A party must not deceive, but in the absence of a rare duty of disclosure, as exists in the case of uberami fidei or within litigation, may remain silent. There is no general principle that the wrongdoer comes under an additional obligation to disclose his own wrongdoing. And Chitty says, there is in general no duty on parties to a contract to disclose material facts to each other. And you can go back to Smith and Hughes way back. Whatever may be the case in a court of morals, says Mr. Justice Blackburn, there is no legal obligation on the vendor to inform the purchaser that he's under a mistake. These are all basic principles that you are not under a duty of disclosure, but now you are. Silence is no longer golden because the cost of silence is the deprivation of your fundamental right to rely on the statutes of peace. So we say those are all powerful factors as to why it is thoroughly sensible to endorse the conventional 3 or 4 stage analysis that you see in the Critty Palm. On top of all of that, you have the uncertainty issue. Because not only do you catch way too many people, but you have to argue about what is and isn't a utilitarian stroke moral duty. So if I want to allege deliberate concealment because I'm time barred, I rub my hands together and say, well, this is fabulous, because all I need to allege now is that there's a risk that you knew you were under a moral or utilitarian duty to disclose something. And all I need to do is allege that, and the case then has to go to trial, which is precisely what Lord Sumption was saying should not happen. The whole point is that you cut off the litigation at the pass. You never get there because you impose clear, certain rules which are easily applied to, quote, foreclose argument, unquote, on certain categories of ancient dispute. It's the language of Lord Sumption. And so you end up, under this new analysis, having to ask yourself, well, is there a moral duty? It's difficult enough. I mentioned this point at the beginning. Is there a utilitarian duty? Even worse. Is there a combination of a utilitarian or moral duty? Even more difficult. And so one ends up in all sorts of trouble with claimants being able to allege very easily that one was under such a duty, and even easier that one knew that one was aware of the risk of such a duty. And indeed, that second question, the question of knowledge, raises questions of certainty too. And that is because if you apply the age-old conventional analysis, you need to know that you are under a legal duty. And as a matter of practice, people tend to know whether or not they are under a legal duty. And that is because the categories are so narrow. So, for example, a solicitor knows that he is under a duty to self-report for negligence. You know that you are under a duty to disclose documents in litigation. You know that you are under an obligation in Uberrimae Fidei and insurance contracts. And there are very few well-established, clearly defined obligations to disclose. And therefore, that issue as well, knowledge of those duties, is nice and clear. As soon as you bring into play the utilitarian stroke moral duty, you then have to work out whether somebody knew of the utilitarian stroke moral duty. So you then have an analysis of, well, do I think there is such a duty in the first place? And if I do I think he knew about it? And these are the sorts of questions which are precisely those you should not be asking in the context of limitation, where you have to have clear, certain rules. Because as soon as you weaken the mens rea under 32.1b and 32.2, as soon as you weaken that mens rea, what it means is that the defendant has to go to trial to win on liability. That's his only way of getting off, because it's so easy for the other side to make an allegation of a moral or utilitarian duty or some sort of recklessness case combined with a moral utilitarian duty. And therefore you end up in precisely that situation which was mentioned in Cave, where the point was made that the whole point of the Limitation Acts is to prevent somebody being hauled to trial on a stale claim, because the only way of successfully defending it is to beat it on liability, because it's so easy to satisfy the mens rea in the Broxby example, because all you needed to show then was that you intended to do the act. And they said, well, that's no good. That defeats the whole purpose. And again, if you weaken the mens rea under 32.2 or 32.1b to include recklessness, precisely the same problem arises. You end up having to go to trial and thereby defeating the whole purpose of the statutes of peace. So we say, in those circumstances, the authorities are very clear, see the Critty Palm, and the authorities since then. Language, I dealt with that as well. It's inherent in the concept of concealment. Statutory purpose, it makes perfect sense, and indeed the utilitarian moral duty causes all sorts of problems. And therefore we respectfully say that the Court of Appeal should have simply applied the age-old conventional approach, which requires you to have a legal duty and to know that you have a legal duty. And we see that in the Critty Palm. So my learned friend then says, well, actually, we take a more fundamental point, that there need not be a duty at all. and that is simply a wrong turn which was made at some point in the authorities, and that instead you shouldn't ask whether there's a duty. And what I've tried to do is summarize my learned friend's new arguments. These are the new arguments which we deal with in our reply submissions, and they're perhaps most easily seen at page 2504. And at page 2504, you will see there reference to, this is our reply submissions, to the first new section 32(1)b argument. And here my learned friend says, well, all this business about duty is a red herring, and you don't need a duty at all in the context of a non-disclosure case. All you need is, and I set it out in 18, consciously electing not to disclose that fact, and circumstances where it was objectively unreasonable not to disclose that fact. This is the supposed straightforward approach. And we say that is so far removed from the statutory objective that it is obviously wrong. And in paragraph 20, what we do is identify what doesn't need to be shown, but frankly what should need to be shown on this new test. And of course, my learned friend's new test, you don't need to show little one, that the defendant was under a legal duty to disclose, or even a utilitarian moral duty to disclose. You don't need to show that the defendant knew or is reckless as to whether it was under such a duty. You don't need to show that the defendant believed his failure to disclose was unreasonable or culpable in any way. You don't need to show that the defendant knew or was reckless as to whether the fact not disclosed was or might be relevant to a cause of action against it. We say that that simply cannot be right. It is much too broad a test. To drag you back to my example of the man who sells a horse who's allergic to hay, if I tweak it to take into account this new argument, I might add a further set of circumstances, which is that I, the seller, wrongly believe that that type of hay is no longer in production. So it doesn't even exist, this type of hay, anymore. But I don't want to tell him that. And I decide I'm not going to tell him that. And I don't feel I'm under a legal or utilitarian duty to disclose that. But I consciously elect not to disclose that fact. And it so happens that it's found that it was objectively unreasonable not to disclose that fact. But I have no mens rea at all. And in those circumstances, that simply cannot be right. That is not what section 32(1)b is all about. You have to have, we say, real mens rea. You have to be guilty of improper conduct. And that is why the duty of disclosure is such a simple and neat way of dealing with the point. Now, on top of that, many of the same points arising out of a moral utilitarian duty type argument arise in relation to this first new argument as well. You have all the same points about an individual who's negotiating a contract with a buyer. You have all the same points about silence no longer being golden. You have all the same points about the age-old tenet that silence is golden being such an important fundamental part of English law, which makes it attractive. You have all the same points about uncertainty. And indeed, if you look at my learned friend's case on this, the one merit that he says this approach has is, and I quote, "The court would have a free hand to determine whether the deliberately withheld fact should objectively have been disclosed, having regard to all the circumstances of the case. But there is no additional threshold test." Now, that is a classic hark back to the discretionary type approach that we looked at right at the beginning when I showed you the index for the Law Commission report, and we looked at the various options. You had concealed fraud, you had the discretionary approach, you had the date of knowledge approach, and the majority of the Law Commission said, no, we need certainty, and so we stick with concealed fraud. In effect, my learned friend is saying, well, actually, no, let's just leave it to the courts to get it right. And I understand that, but of course, the problem with that is it cuts across the purposes of the Limitation Acts. The stated purpose is clarity and certainty, and it cannot be right that you leave it to the discretion of the court in such a way as that, in particular in circumstances where on the face of the test, you do not need any mens rea at all. All you need to do is to have decided that you're not going to disclose the point. It may be completely irrelevant to any claim against you. You may feel you're under no legal obligation to disclose it. You may feel you were not culpable, reckless, negligent in any way. And yet, on my learned friend's case, you can still be guilty of deliberate concealment. That is not what this section is about. On top of that, of course, you've got the difficulty that this case is hard to square with the language of the relevant provisions. You've got the difficulty that this case cannot be squared with the authorities. And the authorities are the Criti Palm, those authorities applying the Criti Palm, Primeo, cases such as that, which all apply the sensible conventional test. And none of them support this new no duty point. My learned friend tries to salvage the no duty point by adding an additional provision that the defendant intends to conceal by hiding from view and keeping secret the fact. He adds that as a third requirement for what we describe as his second new Section 32(1)(b) argument. But we say that's no better and suffers from all the same problems. It's hard to square with the language. There's nothing to support it in the authorities. It's inconsistent with the statutory purpose. And again, if you think of those who would potentially fall foul of it, again, you have your party who is contracting with a third party for the sale of anything. And because those sellers will often think to themselves, I am not going to disclose this as part of my contractual negotiations, because I don't want them to know it. And there is nothing wrong with that. And yet, lo and behold, that party, relying on the basic tenet of English law, is now going to fall foul of deliberate concealment. And we say that that cannot be right. And against that, as I say, you compare it to the simple, conventional, established analysis that you get in the Criti Palm. And we say, that is much the better approach. Now, I've dealt with 2 of the 7 points, and I'm going to rattle through the others much more quickly. You'll be glad to hear. We are, at the moment, due to stop at 4.
We can go beyond then if you feel that would be helpful.
I'd be very grateful if we could sit a little beyond then. I'll rattle through the other points as fast as I can.
Yes. Well, we could go. Subject to our own powers of concentration, we can go on to past.
I'm very grateful. So the next point is, does recklessness suffice? And in many ways, I've already dealt with that. So if you assume that a duty is required, albeit a legal duty or a utilitarian moral duty, we say obviously must be legal, but the question then arises, what is the mens rea for that duty? We say you have to know that you are under the duty. And you get that from all the authorities which we've looked at already, the meaning of the word deliberate, all the references in the Criti Palm to the fact that you need to know, all the references in Primeo to the fact that you need to know, and indeed we say that that's compliant with the statutory purpose for all the reasons I've explained earlier. So all the points which apply to the meaning of the word deliberate for the purposes of 32(2) apply equally for the purposes of 32(1)(b), and that is why the parties are ad idem. It is common ground that the same mens rea applies both ends. So that point can be dealt with very quickly. One then moves on to positive act concealment. So this is a new point which is taken against me. And what is said is that actually this is not a non-disclosure case at all. This is a positive act concealment case. Now, the first point we make is that it is far too late to run this argument. We do take a proper, real, substantive pleading point on this. It has never been run thus far, and indeed is contrary to common ground. It has been common ground all the way up that this is about non-disclosure. And the law in relation to withdrawing concessions in the Supreme Court has set out very neatly in the test claimant's case where this point arose. And your lordships referred to Lord Justice Haddon Cave in Singh versus Das. And for your note, the reference is paragraph 89. In your bundles is 736. But the principles are all entirely unsurprising. An appellate court will be cautious about allowing a new point to be raised on appeal, which was not raised before the first instance court. An appellate court will not generally permit a new point to be raised on appeal if that point is such that either it would have necessitated new evidence or, had it been run below, it would have resulted in the trial being conducted differently with regards to evidence at the trial. And third, even when the point might be considered a pure point of law, the appellate court will only allow it to be raised if three criteria are satisfied. The other party has adequate time to deal with the point, the other party has not acted to his detriment on the faith of the earlier omission to raise it, and the other party can be adequately protected in costs. So those are all unsurprising, but it is a high threshold for withdrawing a concession, particularly when one reaches this level. We say it is far too late now to allege positive act concealment. Now, no application has been made to withdraw the concession, and I do take that point. Formally, one would need to make an application. And I can say that on instructions that had such an application been made, we would have met it with evidence to the effect that this case would have been conducted differently. And that is entirely unsurprising in circumstances where my client, Citigroup, is a substantial bank with substantial reputation. And if circumstances arose in which it was accused of positive act concealment, that is a very different kettle of fish to an allegation of non-disclosure. And in those circumstances, evidence would have been adduced in relation to these points. And we say this is a classic example where it is far too late to make an allegation as serious as that. That is a very serious allegation, because it is an allegation that you have been positively misleading. So we say, no, far too late. What has happened here is that my learned friends have, and I don't blame them, have run with a sentence from the judgment of Lord Justice Mayles in the Court of Appeal, who says that whilst it's been common ground that it's not a case of active concealment, he says, for my part, however, if this question has to be asked, I do not think this answer is correct. The court went to considerable lengths to ensure that the claimant would not know about the commission. Now, I have to say, there was no argument on this at all. It was never suggested in any court up until now that there was any active concealment. And we say, in those circumstances, it is grossly unfair to make an allegation of that gravity at this late stage. There is, in addition, a finding which is made by Lord Justice Mayles, and I do intend to have a short bleat about it, because it is said that salesmen and account managers were instructed accordingly. And that is a finding that somehow salesmen and account managers were instructed not to mention commission.
Sorry, which paragraph are you
Sorry, this is in paragraph 171 of the judgment, which is at page 218. And what my learned friends do is add these together, and they say, well, hold on. So there were some instructions given to account managers, and in those circumstances, this is positive act concealment. And there's no evidence of that whatsoever. That point was not pleaded, it was not argued. It related to an issue which was not pleaded, it was not argued, and indeed was contrary to common ground. And indeed, the finding of the first instance judge, who said this is not a case of positive act concealment. And therefore, we do object vehemently to any suggestion that this should be run at this particular point should be run at this late stage.
You object to the whole of that second sentence in paragraph 171, is it?
My Lord, let me just turn it up.
EF 218.
My Lord, no, not all of it, because some of the points are the subject of findings which had been made against us below.
Could you help us by identifying the ones that you do object to?
Yes, so the one we object to in particular is that salesmen and account managers were instructed accordingly, and documentation was prepared in a way which ensured there was no mention of commission, let alone its amount. Now, it was found against us that a decision must have been made at a high level not to disclose commission. But we say, insofar as that's concerned, that is a classic non-disclosure allegation, in that, of course, we're here concerned with deliberate concealment. So stage one of the analysis is you have to have decided not to disclose it. And they decided not to disclose it. But that is not a positive act concealment. That is a classic non-disclosure falling within 32(1)(b). And so we say one never gets anywhere close to a positive act concealment, even on these allegations in 171. So even if all of those were right, you're still in non-disclosure territory. You're not in positive act concealment. But in any event, we do criticise at least some of those findings on the basis that they weren't argued, discussed, pleaded at all.
I mean, I rather had the impression that Lord Justice Mills here was running together what happened at the time when the credit arrangement was entered into. Don't tell the customers about the split within the premium, with things that may or may not have happened later. Was there an examination of whether there was a deliberate decision, for instance, after Plevin, not to
My Lord, no.
Matters?
No. So the only allegation that I understand now to be made is a new positive act concealment based on the facts in 171. So I understand my learned friend to be saying, because of the findings in 171, I am now going to run a new case of positive act concealment. And we say, as a general hypothesis, you cannot now run that case because it is an entirely different flavour to that which you have run thus far. And my clients would unsurprisingly have taken great umbrage to any allegation of positive act concealment.
Presumably, if the allegation had been made that instructions had been given to salesmen and account managers, if that had been pleaded and made at first instance, you would be able to make the rather forceful point that you make in paragraph 42 of your reply submissions, that you didn't have salesmen and account
my Lord,
managers
yes.
because you were an online bank.
And my client is adamant that no instructions of those kinds were given.
Well, if you didn't have the employees, you could hardly instruct them.
Well, my Lord, yes. But I mean, this all we say demonstrates the difficulty with this. And I understand why my learned friend takes the point, but we do say it is grossly unfair to change from a non-disclosure allegation to a positive act concealment case when one reaches the Supreme Court. And as I say, in any event, we say that even if those findings in 171 are right and fair, they don't amount to positive act concealment in any event. That's classic non-disclosure. Even if my learned friend was able to get up and running some positive act concealment case, questions then arise, well, was the fact something that my clients knew was relevant to a cause of action against them? So all those sorts of points arise as well, which is all the more reason why this is simply not a route that they should be allowed to take at this particular point in time. My Lords, that brings me on to the fifth out of my 7 issues, and that is, was CSO under a legal duty to disclose? And
I wonder, Mr. Kennans, if you could bear with us. It just occurs to me, I think we will actually focus better on your submissions in the next half hour if we take a couple of minutes just to clear our heads and get a break from listening to you, if you don't mind.
I'm not sure what to make of that, but
it's entirely innocent in intention. But there is a certain fatigue that sets in after a couple of hours. So we'll break for literally a couple of minutes and then come back. Yes.
My lords, back to that fifth issue. Was CSO under a legal duty to disclose at all? We say you never get there, because if you find that there is a need for a legal duty and a need for actual knowledge of a legal duty, that is the end of it, because of the concession made, which I showed you right at the beginning. But if I'm wrong, for example, in relation to recklessness, so that you do need a legal duty, but recklessness somehow is sufficient, then the question arises, well, was there in fact a legal duty to disclose? And this is the issue upon which Mr. Justice Jay found in our favour and said, no, there is no legal duty. And in many ways, that is the simplest and shortest answer to this particular point. I think it's most easily seen in our written document at page 112. And at page 112, you're in the midst of our written appellant's case, and at little a at the bottom, CSO was not under a legal duty at any time because section 140A did not give rise to any freestanding legal duty to disclose. And the point is a simple one. Mr. Justice Jay found, and we say rightly, and I should add that, of course, the Court of Appeal didn't consider this point because they didn't need to, because they found that a utilitarian moral duty was sufficient, and therefore they didn't need to consider whether or not there was a legal duty. But if one is required, then at the moment, the judgment of Mr. Justice Jay stands, and we say is right. And he found, at the bottom of 112, in the circumstances of the present case, there was no duty under the common law or the general law to disclose the commission, nor was there a duty to act fairly or in good faith. Lord Sumption's analysis in Plevin reinforces this. See paragraphs 19 and 20, including his statement that the court's powers to remedy unfairness under section 14A are not predicated on there having been any such legal duty. And CSO respectfully agrees. And so that in many ways is a very short point. But we say fatal in any event. If we're wrong on that, then a further point arises, which is whether or not you can recycle the same conduct which constitutes the breach as constituting deliberate concealment. So, in a nutshell, the point is this. If you have a non-disclosure case, you look at whether or not the non-disclosure was in breach of duty and therefore a deliberate breach of duty under 32(2). And if you fail on that because you cannot satisfy the criteria of 32(2), can you then say, well, I am recycling that very same conduct as deliberate concealment? And we say, no, you can't do that. Deliberate concealment has to arise out of conduct which is different to the commission of the original breach. And you see that from passages such as that I cited originally, referring to Bully, where they say, in the absence of a case of subsequent active concealment, you can have a section 32(2) case where you look at the breach itself. But when you look at the breach itself, you have to get within 32(2), which has specific statutory criteria, such as the fact that the breach must be one which is unlikely to be discovered for some time. That's specific to 32(2). And we say you simply can't recycle the same point as deliberate concealment as well. And we say that good authority for this is to be found in the Kitchen case, which is cited at paragraph 136 of our written case, which is 114. So page 114, and you'll see there at 136, we cite Kitchen, and we say, the first ground of the judge's decision was, I understand it, that the original failure by the appellants to inform the plaintiff in regard to the limitation of time, in regard to a possible claim under the Fatal Accidents Act, was itself not merely an act of negligence, but also constituted concealment by fraud. In this matter, however, fraud in the section is to be defined. I'm unable to agree with the judge's conclusion. No doubt in some cases the facts may be such that the circumstances of the wrongful acts may also constitute concealment by fraud. For example, where the wrongful acts are continuous and are also surreptitious. Such was the case, for example, in Bully Coal Mining versus Osborne. So the point he's making there is if you have a breach of a particular nature, then you can qualify as a bully-type breach, brackets, and you're under section 32(2). But what you can't do is to say, well, I rely on that very same conduct as constituting the breach, brackets, unfortunately I can't get home on 32(2) for whatever reason, but I'm going to recycle it, precisely the same conduct, and I'm going to get home on 32(1)(b. Would be a most peculiar result. And 32(1)(b) non-disclosures are all about a scenario, for example, where you have a breach, an original breach, and then somebody becomes aware of that original breach and decides not to disclose it, such as the solicitor, who negligently draws up contractual documentation, and at the time they don't realize it. They then see what's happened a year later, and they are then under a duty to disclose, and that's a classic 32(1)(b) case. But what you can't do is say, oh, well, I'm going to have a go at deliberate breach, but I fail, unfortunately, on 32(2), but I'm going to have another go under 32(1)(b). And you'll see as I read on at the bottom of 114, such was the case, for example, in Bully, but that's a 32(2) point. I will cite a sentence from the head note to show what the position in that case was, where the appellants had furtively for a series of years taken the respondent's coal by a means of a willful and secret underground trespass. That, however, is not, in my judgment, the present case, and I'm reading over from 115. Indeed, a decision to the effect that the failure to inform the plaintiff while being an act of negligence also constituted the requisite concealment by fraud would be contrary to the decision in Wood and Jones, where it suggested that the failure of the solicitors to give the client proper information as to evaluation also constituted the necessary concealment. That suggestion was rejected, in my judgment, rightly so, by Kekowicz J. And my learned friend says, well, frankly, you should be able to go back to 32(1)(b), because even though there are specific requirements under 32(2) that the breach needs to be one which is unlikely to be discovered for some time, much the same applies under 32(1)(b), because there's due diligence obligations. But of course, they're looking at different times. 32(2), you are isolating the breach, and you are considering the question, was there a deliberate breach? And was it a breach of such a nature that it was unlikely to be discovered for some time? And that focuses on a particular time period. And it's not right to say that that timing issue is the same under 32(1)(b). It's under 32(1)(b), if you have deliberate concealment, you then cannot rely on it until you reasonably could discover the particular fact. But that, of course, is all after the event. And so the point is, you're looking at different time scales. And therefore, it's not right to say that they are on all fours. So we do say that that, in and of itself, is fatal. My learned friend says, well, look at Sheldon. But Sheldon is all about whether or not you can have a breach and concealment at the same time, but not by virtue of the very same act. So, for example, you could have a solicitor who is negligent in drawing up a contract and knows that he is negligent in drawing up a contract, because at that point in time, he has both deliberately breached a duty in that he's been negligent, and B, at the very same time, because he knows he's negligent, he's under a separate duty to reveal that. And that would be, potentially, both breach and concealment, which happen at the same time. But it's a very different case to say you can rely on the very same non-disclosure as constituting both. That is to try and use the same underlying act in two capacities. Whereas in the example I've just given you, there are two different acts. One is the negligence, and the other is the failure to disclose the negligence. They're different. And so we do say that you can't simply recycle it. And my learned friend will say, well, what about if you're under a continuing duty? So in other words, every day you are under a fresh duty to make a disclosure. But of course, the correct analysis there is you are subject to a repeated selection of 32(2) breaches. And if you ask yourself, in terms of analysis. Is the correct analysis that when I do the same non-disclosure on day 2, I am concealing my disclosure on day 1? No, we would say. That's the wrong analysis. It's simply another breach which attracts the attention of 32.2, and you're either with it or without it. And we say it's as simple as that. But these are all interesting points, but we say one doesn't get close to needing to resolve them, given what we say is such a clear result on the recklessness issue and the legal duty point. The 6th point is the lazy solicitor point. And you'll recall that when I took you to Lord Justice Males's summary of the issues, which was at page 225, this was his question 5. You'll recall that question 4 was missing. This was question 5. Do you need to show as well that the defendant knew that the fact was relevant to the right of action against it? So the lazy solicitor goes on holiday. He doesn't disclose matter X, but he has no idea that that matter happens to be very relevant to a cause of action against him. Is that sufficient? We say obviously not. He must know that it's relevant to a cause of action against him. That is what this section is all about. Now, I need to deal with one point briefly here, and that is the suggestion that I see in my learned friend's submission that what the Court of Appeal was finding was that items 3 and 5 were alternatives rather than additional requirements. So if I can just go back to page 225 just to explain the difference between us here. So at 225, you'll see at 199, Lord Justice Males sets out items 1, 2, 3, and 5. And he says that you are required to ask a series of questions. And the 5th one is preceded by the word and. And we say that what he is clearly saying here is that you need both. And my learned friend is saying, well, actually, the Court of Appeal were finding that you needed either 3 or 4. And we say that that is obviously wrong. I don't know if this is a submission which will be maintained, but it's obviously wrong, both on a reading of Lord Justice Males's judgment and on a reading of Williams, which is the source of the lazy solicitor point. If one looks back at page 224, you can see the answer to this point. At page 224, just to give you the reference to where my learned friend says that it's either or, the reference, just for your note, is page 137. But at page 224, you'll see Lord Justice Males referring to Williams, and he says, Mance LJ then referred at 37 to 2 possible interpretations of 32(1)b. A narrow interpretation which required the defendant to know that the concealed fact was relevant to the claimant's right of action, and a wider interpretation which did not. So that's the lazy solicitor point. In both cases, however, it was at least implicit in Mance LJ's formulation that in the case of an omission as distinct from active concealment, the defendant had to know that the failure to speak was a breach of duty. So he's making it quite plain there that it is an additional requirement, not an alternative requirement. And indeed, it's obvious that that's what Lord Justice Mance was thinking, because otherwise the lazy solicitor conundrum would have answered itself. Because if my learned friend's right that you need one or the other, then of course the lazy solicitor knows he's under a duty to give the relevant piece of information to his client. So he knows there's a duty. So on that hypothesis, if either was sufficient, Lord Justice Mance would have said, well, there is no further point. You can get home on either. So the lazy solicitor issue has solved itself. The whole point was that Lord Justice Mance, in positing the lazy solicitor issue, was looking at whether there was an additional requirement. And we say that is what the Court of Appeal found, that there was an additional requirement, and that's what Lord Justice Males is saying in 199. We say he's right to make that finding, and we say that recklessness is not sufficient again for the purposes of that finding. And in certain circumstances, That in and of itself, this particular issue, we say results in the appeal having to be decided in our favour if one reaches that particular stage of the analysis. Because on that hypothesis, my learned friend would need to show that my clients knew that, not reckless, knew both that there was a legal duty and that the fact was relevant to a claim against them. But one never gets there for all the reasons I've explained already. So in terms of how far one needs to go in analysing Lord Justice Mayall's analysis at 1 to 5 of paragraph 199, one need never get to item 5. But if you do get to item 5, we say it's right, and in any event could potentially be significant. That leaves me with one other point to deal with, which is the 2014 argument. And I think the neatest way of dealing with this and the quickest way of dealing with this is to invite you to look at page 2511 of our written reply, where we try and unpick the argument. And I hope that that will demonstrate to you why we say the argument never gets off the ground, because the point appears to go as follows, as we say at 2511. So proposition 1 is that a utilitarian moral duty will suffice. And we say, no, it won't, and therefore that's the end of it. That's the end of this argument. Because, of course, if my learned friend needs a legal duty after the end of the relationship was in 2010, he doesn't have one, and he can't allege one. So if it's a legal duty required, this point never goes anywhere. But let's assume a utilitarian moral duty does suffice. Then he then says CSO was under a utilitarian moral duty to disclose the commission following the judgment in Plevin 2014, and that CSO knew following the judgment that it was under such a duty. And we say, well, hold on, one simply cannot make those findings on the state of the evidence as it is at the moment, not least because no allegations have been made and no evidence has been adduced in relation to what would happen in 2014. And my clients would make the obvious point that their relationship with the claimant came to an end in March 2010. And as far as they're concerned, Plevin comes out 4 years later, 8 years after the contract has been concluded, and 4 years after the relationship is terminated. Plevin then comes out, and is my client then to think, well, because of Plevin, I now need to make a disclosure in relation to a contract I entered into 8 years ago, which terminated 4 years ago.
Well, I suppose you'd look at a block of contracts, wouldn't you? You'd look at a pattern of behaviour.
Yes, that may be so. But the point is, difficult factual issues arise in relation to this, and therefore, at the very least, we would say that if this argument got off the ground, which it doesn't, then real questions arise in relation to the knowledge issues for the purposes of the 2014 argument. You've got to have a duty, and we've got to know about it, albeit that duty is years later after the relevant agreement. And it may be, Your Lordship takes the point, well, it may be that you do look at some agreements, those that are still in force at the time of Plevin. But those which have long since been gathering dust, 4 years after the relationship is terminated and 8 years after the agreement was concluded, why should you, at that point, start A, being under a moral utilitarian duty, and B, being know that you're under a moral utilitarian duty to disclose anything? Circumstances, again, where even at that point, the FCA are not obliging you to do so. So that's the 2014 argument, but we say it never goes. The simplest answer is we are not in the territory of utilitarian moral duties in any event. And in the absence of that, the argument doesn't get off the ground in the first place.
Can I just ask, what's according to you, is the relevant start date for the limitation period? Is it entering in? No, it can't be entering into.
It enters in, entering into the contract, but there is a case called Patel, judgment of Mr. Justice Leggett, which says that the cause of action continues to accrue on a daily basis throughout the relationship.
So that's the cause of action under section 100.
Yes, because under section 140A, your relationship is unfair, and it remains unfair potentially until the end of the agreement. It may be that on the facts it ceases to become unfair, but potentially you could be in breach for the longevity of the relationship, but you cannot be in breach after the end of the relationship. And I do believe there are some cases, funnily enough, on whether it is possible for you to cease to be in breach during albeit your relationship initially was unfair. And I think the answer is you can have a scenario where it was unfair but ceased to be unfair at a certain point in time.
Right, but you don't maintain such a case?
No.
For the purposes of this hearing. So is it the 8th of March 2010 is the end of the relationship, and in effect it's 6 years from then, subject to section 32?
Correct.
Okay.
Yes. I'm glad. I think I've got that right.
Yes, all right, thank you.
My Lords, I've whittled on all the way through to 4:30.
Well, that's very self-deprecating. Well, shall we adjourn then for the day? And if you have any, if you experience any esprit le scalier, you can address us some more.
My Lord, perhaps if your Lordship rises, I'm the one who's missed out as a consequence of what's happened there. My learned friend's actually used his exact level of time because he missed an hour and a half for a random case.
Oh, I'd lost track of that. Yes,
and he's now carried on from the 3 o'clock he was going to end to the 4:30. So he's had his allotted time, and I wouldn't expect there to be any moments of enlightenment to trouble the court tomorrow morning, or any questions from the court to seek any moments of enlightenment. We've had plenty today, I hope. So I'm hoping, my Lord, that my learned friends can put
You're quite right, Mr. Ware.
Because this court is very strict, ordinarily at least, in terms of timing, and dare we ever seek to push the boundaries? But I'm about to now, because whilst I understand again, my Lord, the encouragement towards brevity, I anticipate that the court setting this case down for 2 days was accurate, completely accurate, and it will take 2 days. In other words, I'm an hour down, and regrettably, my Lord, I'm very anxious, because if we start at 10:30 and then the hunger pains are kicking in at 5 to 1, it may be that your Lordship's multiple obligations, way beyond simply hearing this case, then don't encourage your Lordship to come back before 2 o'clock. It may then be that the same factor, but probably earlier, kicks in with regard to the difficulties of listening to counsel for an extended period of time, kick in before 4 o'clock. And so I'm wondering, my Lord, but obviously subject entirely to the multiple obligations of this court, whether we might start at 10 o'clock.
I don't think that's possible, because one of the members of the court, one at least, is handing down 3 judgments at 9:45, but we may be able to start early.
Yeah, I think that should be clear by 10:15.
Yeah, we'll start 10:15 now.
Yeah, I think we'll try to start at 10:15.
We'll aim to start at 10:15, Mr. Ware.
Well, I'm very grateful, and I'm afraid, my Lord, I may trouble the court again.
Yes, I understand.
On an ongoing basis.
Yeah.
Or, as I've explained to my friend, it may be I'll start to eat into his reply time and then make the problem his problem, not my problem.
Well, we'll keep an eye on things, and maybe we can cut down the lunch adjournment, for example.
I fear tomorrow that may be very helpful, Lord.
Yes. Very well. I mean, don't worry. We are very sympathetic. I mean, we appreciate the difficulty that this causes you.
No, my Lord, no difficulties at all. Just timetabling for tomorrow.
Very well. We'll adjourn that until 10:15 tomorrow.